So a federal district court just issued a nationwide injunction which blocks the ATF's pistol brace rule, and then it blocks it in its entirety. So we need to talk about what this order does and what happens now going forward. But real quick before we jump into this video, if you think the ATF's pistol brace rule is clearly unconstitutional and should be struck down nationwide, go ahead and hit that like button and subscribe. So like I mentioned in the intro, we just received a major decision against the ATF's pistol brace rule. A nationwide injunction has been issued against the ATF and that pistol brace rule, and that's a nationwide injunction enjoining the rule in its entirety. This is something everyone has been wanting, and we finally got a nationwide injunction. The case we're going to be talking about in this video is called Brito v. ATF. This is an order that was issued by a judge, Judge Matthew, and I'm going to mess up his last name, Karsminski, and he just struck down and he just issued a major injunction against the ATF pistol brace rule. This ruling by Judge Matthew springboarded off of the recent decision by Judge Reed O'Connor in the Mock v. Garland pistol brace case. However, in this Brito case, the judge went at the extra mile and actually granted what was requested, a nationwide injunction, an injunction against the entire pistol brace rule, and again, it's a national injunction. Now, you may recall that in the Mock v. Garland case, the judge also issued an injunction, but the injunction only protected the members of FPC, and again, that was against the pistol brace rule, so it was much more limited. Then you had some other cases like the GOA case and the NAGR case, which also got similar results, which protected their members. Well, this Brito case and the decision here went beyond just protecting the individual plaintiffs, and it actually gave an injunction against the entire rule. So we need to look at what the order did, and then we need to break down what happens now going forward, because I think there's a lot of commentary and discussion and articles going around right now talking about the decision, but not really giving you guys a full picture about what this order does and really where this case goes from here. So now the first thing we need to explain with this decision and the impact of it is that this is a granting of a preliminary injunction against the ATF and that pistol brace rule. A preliminary injunction is a temporary form of relief that remains in place only until the case is fully decided on the merits of the arguments. So this order blocks the enforcement of the pistol brace rule only until the case is fully decided on its merits. So if you hear anyone in an article or discussion saying that the case has been fully decided on the merits and has been struck down entirely because the case is done, that's not necessarily correct. In fact, the case is still a long way from being done, and we're going to talk about some of the things that probably the ATF is going to do going forward. Now, to get a preliminary injunction, a party must show four main things. First, a likelihood of success on the merits. Second, irreparable harm in absence of the preliminary relief. Third, that the balance of equities tips in their favor. And finally, and fourth, that an injunction is in the public's best interest. So those are the main four things that a plaintiff would need to show to get a preliminary injunction, again, that temporary form of relief. So that is what the judge was reviewing in this Brito case. He needed to determine if the plaintiffs met all the factors to get their preliminary injunction against the pistol brace rule. Well, the judge on review found that the plaintiffs showed all of those factors and he granted their preliminary injunction. Now, in the decision, the judge stated that this court does not begin with a blank slate. As the parties have acknowledged, the recent case of Mock v. Garland provides substantial guidance. Given the Fifth Circuit's holding, this court recognizes that the rule was not a logical outgrowth of the proposed rule and must be set aside as unlawful. So that is what he said here. That is what the judge here in the Brito case is saying. He's agreeing with the Mock v. Garland case, and he is springboarding off of that decision by Judge O'Connor in the Fifth Circuit to now issue his own decision. Since the Fifth Circuit and Judge O'Connor already found that this rule violates the APA, he really didn't have to do much work in this decision, and he's kind of just using a lot of that language to issue his own ruling. He did state that he did not move on to the Second Amendment violation question and that whole issue because the rule fails from the start under the APA, so he doesn't even need to look at the Second Amendment question because the rule pretty much just fails at the very beginning. So because of the Mock decision, the likelihood of success on the merits factor was automatically carried over into the Brito case and given to the Brito plaintiffs. He then goes on to look at whether the individual plaintiffs will be irreparably harmed. And of course, he found they clearly will be harmed by this pistol brace rule. He identified that the plaintiffs would incur potential costs for compliance. They would have to potentially register before the deadline. If they didn't do that, then they would need to turn over the brace pistols, modify them, destroy them, and all of that would be costs and it would clearly harm the plaintiffs. Finally, he then moved on to the last factor, which is looking at the public's best interest and looking at whether or not this would harm the government and the public. And on that factor, he found that there is no way the government could argue that they would be injured or that there would be injury to the government or the public because this rule that is put in place violates the APA. He then concludes his decision by pretty much just going full Chad, just absolutely destroying the ATF and this final rule on pistol braces. He states that the court is not insensitive to the ATF's concerns over gun industry gamemanship and attempts to circumvent the NFA's restrictions on SBRs. However, the government may not simply posit that the regulation promotes an important interest to justify its regulation. There he is directly quoting to Thomas in Bruen. He goes on to say that, of course, some form of protest can be expected when constitutional rights are allegedly infringed. The passage of time and the development of new technology can also reveal latent ambiguities in a statute. Likewise, the court is certainly sympathetic to the ATF's concerns over public safety in the wake of tragic shootings. The rule embodies salutary policy goals meant to protect vulnerable people in our society. But public safety concerns must be addressed in ways that are lawful. This rule is not. And he says, for the foregoing reasons, the court grants the motion and stays the rule in its entirety. So the judge granted the preliminary injunction, striking down the pistol-based rule in its entirety. Now, you may be asking, what does this mean for you, and what does this mean going forward? Well, the decision does halt the rule nationwide for everyone, not just members of organizations like FBC, GOA, NAGR. This is an injunction against the entire rule. However, I do want to warn everyone that this is a nationwide injunction, but it's likely not going to stand for very long. First and foremost, we know that the ATF is going to appeal that ruling and also seek an emergency stay of this decision to the Fifth Circuit. They might have already done that by the time I release this video. So the tradition is that the ATF will appeal this. We know they're going to appeal it, and they're also going to seek a stay of this decision. And if the Fifth Circuit doesn't grant that emergency stay and doesn't do it fast, then the ATF will go to the Supreme Court once again. Keep in mind that very recently in the Vanderstock ATF frames and receivers case, the Supreme Court overruled a nationwide vacatur of that rule. The Supreme Court appears not to like the fact that Judge O'Connor, a district court judge, vacated the frames and receivers rule in its entirety nationwide. Then also in that Vanderstock case, keep in mind, there was a follow-up review by the Supreme Court on a more limited injunction that protected only specific companies and their customers, and even in that limited situation, the Supreme Court also did not like that injunction. The fact that the ATF has already been successful getting the Supreme Court to grant a stay on a nationwide vacatur of the frames and receivers rule, and then even putting a halt on more limited injunctions against the frames and receivers rule, I would fully suspect that the ATF is going to try to do the same thing with this national injunction on the pistol brace rule. We also need to keep in mind that the Supreme Court recently took review of the Cargill bump stock case. I would not be surprised if the ATF on appeal first, seeks the appeal to the Fifth Circuit, seeks that emergency stay, and then along with this case and other case, probably now is going to try to get a lot of these cases put on hold because of that Cargill decision, which is currently going to be issued at some point. We're going to have oral arguments in Cargill and then issued by the Supreme Court. If the ATF wants to stop the bleed in the Fifth Circuit because they're losing all these cases right now, the best bet for them probably would be to try to put a hold on all these cases like we saw the Ninth Circuit do when Bruen was pending in the Supreme Court. A lot of the cases got put on hold, and so that might be something the ATF is going to do as well in this case and other cases in the Fifth Circuit. Not only would it buy them more time, but also give them a stronger argument for even the Fifth Circuit to grant a stay on a nationwide injunction if they are asking for these cases to be put on hold for Cargill. I still want to remind everyone that you still have those membership protections, regardless if this nationwide injunction and the nationwide decision is stayed by the Fifth Circuit or the Supreme Court. But the hope is that the nationwide injunction will stay in place. But mainly who this is potentially going to hurt is any gun stores or companies who want to still be able to sell braced pistols who haven't been able to. That is the broader implication of this injunction, which entirely enjoins the pistol brace rule. I think a lot of companies are potentially excited and a lot of gun stores are excited to be able to sell, and maybe a lot of purchasers are excited to finally be able to still once again go out and purchase braced pistols. But I would warn everybody, again, be very careful for the next week or so. There can be a lot of drastic changes and a lot of things could change. And again, my anticipation is that the ATF is going to appeal this up to the Fifth Circuit, and this is probably going to find its way up to the Supreme Court if the Fifth Circuit does not grant the stay. The question going forward now really is whether this nationwide injunction will stand and will not be stayed by either the Fifth Circuit or the Supreme Court. So again, still a huge win. A nationwide injunction has been issued against the pistol brace rule, but this is something we definitely need to be watching closely over the next few days and the next week, because a lot could change very significantly and could impact a lot of people. Make sure you're subscribed to the channel. Make sure you have all notifications turned on if you're subscribed, so that if anything else changes and I put up a video, you're notified, and so you can find out very fast. So as always, thank you guys so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.